When can you modify your visitation schedule in Oklahoma? I'm Tulsa Attorney James Worth. That's the question that we have. And it goes mostly to this case from the Oklahoma Court of Civil Appeals, Swiney v. Villanueva. It is 2021 OK CIV APP 37, and it deals with what is the standard to modify visitation. For modifications, when we're talking about kids, normally we go to one thing, and it's the Gibbons standard. And that's what they were trying to push for in this case. The Gibbons standard says that you can modify when there's been a substantial, material, and permanent change in circumstances which directly affects the best interest of the child to where the child would be substantially better off if that change were made. So it can be a high standard to make. We've got to look at, once after the last order was entered, what has changed, and that change has to affect the best interest of the child to make it in the best interest of the child to do a change, and it has to be substantially better off, and it has to be substantial, material, and permanent. So does this standard apply when you're requesting a modification of visitation as it does to other types of custody modifications? And that's the question that came before the court. And ultimately the court said that there's no case law in the state of Oklahoma that has ever said that the Gibbons standard has to apply to visitation. What it says is that Oklahoma statute in Title 43, Section 112A3, grants the trial court the authority to modify visitation whenever the circumstances render the change proper. So it's a lower standard than what we're talking about in the Gibbons standard sometimes.